Hello and welcome to this talk on the public access scheme. This is the scheme that gives members of the public direct access to the use of barristers' services. This is the second talk in an occasional series, and I'm going to be talking about preparation tips that you can use to save you money and help to instruct your barrister more effectively. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. So in this talk I'm going to be talking about preparing to find a barrister and what may help you. We're going to cover things like why it's worth preparing information, how to prepare the information you send to the barrister, how to build a chronology or timeline of events using a table of events, how to help yourself to separate facts from your opinions, and how to analyse the facts that you want the barrister to consider. To a limited extent, how to use the legal structure that you're dealing with, the law, how to deal with documents. And also I will deal with the importance of reaching a clear agreement with the barrister that you're trying to instruct. So why prepare? Well, it'll save you time, it'll save you money. It should focus your mind, and it should focus your barrister's attention onto what you really want them to consider. It should enable you more effectively to obtain the advice you really need or the representation you want to obtain. So, how do you prepare? Try to be clear in the information that you send, and try to be objective, and that can be quite difficult for somebody who's trying to deal with a series of events which have happened to them and may be very emotionally charged for them. So I suggest you use a preparation method, something to make you slow down, stop, try and take the emotion out of it to the extent that you can. So write down what you want to say, but having done that, then question it. Have you covered when things happened, where they happened, what happened, and who did what? You might think that it's important to give a lot of context. Try to give the context that is relevant to the issues that you want the barrister to advise you on or to represent you in. So it's really important at the start of the process that you have all the dates in order and that you can give relevant details. Try to be specific, in other words. So I'm going to talk now about how to make a timeline or chronology. I'm recommending that you use a table for this, just because it helps to structure your thoughts in a way that simply writing down paragraph after paragraph of material may not. It is also a core document in the preparation of your case, and if you start it early, then you'll be able to build on it later on. So here's an example of the types of columns that I think would be useful for you to have. So the first column would be the date column. I'm recommending that you use a consistent date format. If you're using a word processor to do this, then you'll see why later on. Then when you come to describe the events, then try to describe them neutrally, give the barrister the facts rather than a lot of interpretation that you're putting on them. So that somebody entered the room is a fact, somebody entered the room in an insulting way is going beyond the facts and putting your interpretation on it. So if you try at least at the beginning to put the facts as neutrally as you can, you'll see later on there's a column that I've included for your comments, and separating out the facts from your comments on the facts or your feelings about the facts could be very important in some cases. But the next column is where you identify documents which might give support to event that you're talking about. And in fact, it might be something that's been said in an email that you want to complain about, for example. So you would identify the document, or you would try to identify anybody who might be able to give evidence about the event you're talking about. And then finally, there's the column for comments. That's where you put any reasoning or feelings about the events that you think may assist the barrister. If you're using a word processor to construct the table, then if you use a consistent date format, some word processors, most word processors, will allow you to reorder the whole table by reference to the date order, and this has certain advantages. I think when we're trying to write an account, it's very difficult to get everything in crisp chronological order right from the start. This method of writing the events down in a table but using a consistent date format means you don't have to worry so much about that, and you can write what happened and then make sure everything is in chronological order by getting the word processor to reorder your table. So put the events down in the table, press the button on the word processor, and it should all go into date order. Being neutral. If you use the method I'm going to describe of writing your version of events down and questioning it, it may help you to separate facts from interpretation. So what is this method? It's one method amongst many. First of all, you write down what happened. But then you ask yourself a series of questions. If I was a stranger reading it for the first time, what else would I need to know before it made sense? Now this helps you to identify the assumptions that you're making, and it enables you to explain the thing that you're making the assumption about. So you might work in an environment, for example, where it's very well known what a particular acronym means, and you've simply put that acronym down in your version of events. Now the barrister, who doesn't work in that environment, needs help there. They need to have the acronym spelled out for them, because then they'll realise the significance of it. So things like that need to be spelled out, and one good way of identifying them is using this question. If I was a stranger reading this for the first time, what else would I need to know before it makes sense to me? Ask yourself whether you've told the stranger the facts, or have you simply mixed up facts in your interpretation of those facts. Using the column method and the table method should help you to avoid that and to give a much clearer version of events to the barrister who you wish to spend time dealing with your problem. Essentially, the writing and questioning method allows you to ask the question, have I identified who did what, where, and when? These are the absolute essentials of telling a coherent story. It allows you to ask whether you've identified the witnesses to each event, and the documents similarly. You can also make sure that where it's relevant, you've told the barrister, the stranger, about any reaction that you had. Ask yourself also whether you noticed that feeling at the time, or whether it was after the event, looking back on it. Because sometimes that can be relevant to particular things that have happened. Very often it can be quite important in relation to things that have happened at work. The legal structure on which you hang your claim is very important. It's almost like a clothes horse. There are certain elements that you have to hang your case on. Every legal claim, in other words, has parts that have to be proved. For example, and in very broad terms, in a contract you'd need to be able to identify that there was an offer made, that there was acceptance of that offer. you'd need to be able to point out what the breach was, and you'd need to be able to point out what loss was caused by the breach. In other types of wrongs, you'll hear them referred to as torts. You need to be able to show that there was a duty of care, that there was breach of that duty, and that there was loss caused by that breach. Now, some of those are things on which you'll need the advice of a lawyer. And then there are statutory claims. Now, in fact, these are a little bit like the non-contractual wrongs or torts that I've mentioned. But for those, you can go to the statute that you think may be involved, have a look at the detailed wording of the statute. These effectively create the duty that the other party owes to you. You've got to be able to identify whether you satisfy that wording, and then you've got to be able to show how any particular part of that section was breached by the other side, and you need to be able to identify loss caused by breach of that particular part. Now, as I say, those are very general terms. In particular, in relation to statutory claims, I suggest you look at the part of the statute that you think your claim is based on. Can you see what you've got to prove in order to show that the wrong was committed? Now, if you can, then you should try and relate the facts of your case to that framework. In many cases, as I said, you'll need advice to find out whether they do relate or not, but it gives you a sense to begin with if you can go and have a look at the statute. And most of the statutes that you'll be interested in, they'll be available on the government's websites, which publish the texts of the statutes. You don't have to get it right at this stage. If you can use this statutory clothes horse, as it were, it may help to structure your thoughts. But if you can't do that, don't worry. You can ask the barrister to do that work. The whole point of trying to do it in advance is that it gives you some sense of where you're going, and it may well save you a bit of money if it becomes quite apparent to you that actually you're not going to be able to take the case forward. On the other hand, you can always ask a barrister to advise just on the basis of the facts that you've got together as to whether or not he or she thinks that there's any legal claim there. I want to say something about documents. You'll ask yourself whether you should send everything you've got, but this of course is expensive, so a better way of dealing with this is to try to be relevant. Now, sometimes that's easier said than done. How do you identify what the relevant documents are? Well, if you've gone through the table that I've suggested you use as your core document, you'll already have identified documents which prove or support the facts that you're asserting in your events column. But at this stage, you can run a sort of double check by asking whether those documents that you've identified are necessary, or whether you just like them for other reasons, because, for example, they show the other side up in a poor light. In other words, that they have prejudicial value. Well, prejudicial values all very well, but remember, your barrister is going to be looking through the documents and be charging you for that process. So for the moment, at any rate, I'd suggest that you leave documents out which are simply there because they simply show the other side in a bad light. Remember, you should tell the barrister that you haven't sent everything, because they can ask you for what they need or what they wonder whether you've got. Also, you may realise that a document is relevant to you as the relationship with the barrister progresses. I want to move on to some other tips now. You can always talk to the barrister's clerk, and they'll help you to try and find the right barrister in terms of cost or level of experience. Always feel free to expand on the inquiry form that you find on a Chamber's website. And once you're in dialogue with the clerks, then you can expand on it, for example by telling them that you have constructed a table of events. And most barristers will be very grateful for receiving that, because it shows that you've structured your thoughts before approaching them for advice. And actually that makes it more likely that you will find a good barrister who wants to take on your case, because they will understand your case much more quickly in that way. Always remember to bring identification to the first meeting, and in order to comply with the money laundering requirements, the barristers' chambers will be asking you to establish your identity at the first meeting, or indeed before it. Remember that you pay for advice and skill, and not necessarily for results. Very often you'll go to a barrister and they won't tell you what you want to hear, but they will advise you and they will use their skill to do so. So remember, that's what you're paying for. Barristers who do direct access work will frequently build into their client care agreements working hours. So for example, they may say, I will not deal with emails between the hours of, let's say, 6 o'clock and 9 o'clock, 6 o'clock at night, 9 o'clock in the morning. So do try and respect those working hours. What's essential is that you're clear on each stage of the work you want them to do. The vaguer you are about what you want them to do, the more risk there is that you'll have a disagreement about what work fell under the agreement that you had with them. So it's better to ask the barrister to do as specific a job as you can describe, and preferably to set down what you want them to do in writing, and then your agreement with them can simply refer to the email, for example, that you've sent. The barrister will send you a client care letter or agreement for you to sign. You should read this very carefully. Make sure you understand what you've agreed to pay for. Also, and some people find this quite difficult, each new stage of work requires a new client care letter or agreement. So you agree each phase of the work that you want them to do. Now it's worth having a talk with the barrister at the start about the way in which your work can be broken down into discrete sections. So for example, you might want to talk to them about getting an initial advice, either in writing or seeing them in conference. That will be separate from, say, writing a letter before claim to the other side, and that'll be different again from drawing up any pleadings, your statement of case, or other document that you might want them to write for you. So remember that it is better to have a discrete agreement for each phase of the case. That enables you to manage the budget much more carefully. It also means that the barrister knows exactly what they need to do for you. So reach a clear agreement. Different barristers obviously have different approaches to reaching agreement. Now I suggest this method of putting what you want down in writing and saying to the barrister, this is what I want you to do. I want you to do the following. And I've given a couple of examples there on the slide. One of the questions that you will need to think about if you're looking for advice is whether it's better for you to meet the barrister in conference or ask them to give a written advice to you. Well, there are advantages and disadvantages. the advantage of a conference is that a barrister can ask you questions about what you say happened and can explain the law to you or clarify your understanding of what you can do. It's a much more fluid way of discussing tactics and procedure. You may remember something as a result of the questioning that's going on, which helps the barrister to advise you. There are disadvantages, the chief one of which is that in some cases where you're looking for advice, you need to reflect on exactly what has been said, and actually you can do that better if you've got a written message from the barrister. You can have both, and if you're not sure which would be better for you, ask your barrister to suggest which is better in your case. There are some practices surrounding getting written work done which you ought to know about from the start. If you're asking a barrister to give you written advice or draw up a document called a pleading, so a claim or a defence, you'll often find that the barrister will ask for payment for written work before they release the document to you. So what you should do is to get a time estimate, so an estimate of how long it's going to take the barrister to do the work. Make sure that there's an agreement to notify you that if the time taken looks as if it's going to be exceeded, then they won't do additional work without your permission. Also, make sure you've given all the relevant documents as early in the process as you can, because one of the things that pushes the time estimate up or causes the barrister to have to come back to you to say, well, I'm not going to be able to get this done in the time that we've agreed as my estimate, is the fact that the client sends through additional documents after the agreement is reached. So if what you're looking for is some certain agreement, it's much better to send your documents through as early as you can so that they can be taken into account when the estimate of time is given to you.